Hello, my name is Michael Tesoro, and I'm preparing this little case note about a recent case in the federal court concerning the banking cartel. And the case relates to the indictment and the attempts by the defendants to quash that indictment. Just quickly about myself, my name is Michael Tesoro. I run a business called Tesoro Legal Consulting, which I've been running for about 15 years, generally competition and consumer law. I'm also a former ACCC officer. I was a Director of Enforcement at the ACCC in Sydney for a number of years. I ran a few cartel cases and also a couple of criminal prosecutions. So I'm just seeking to bring some of my insights to this case and help people understand what happened. So just outlining what I'll be talking about, I'll be looking at the decision of Justice Wigney of the Federal Court in relation to the Citigroup case, which, as I said earlier, is an attempt by the defendants to quash the indictment. And it's fair to say they had a high degree of success in their attempts to at least have the prosecutor redraft the indictment yet again. So just a background to the case so people can understand what's been alleged by the ACCC. The conduct arose from an ANZ share placement back in 2015, and the underwriters were Citibank, Deutsche Bank and JP Morgan. And what was alleged was that there was a shortfall in the subscription to the offering to 25.5 million shares valued at 800 million, so quite a large undersubscription. And as people know, underwriters have to pick up that shortfall. So what the ACCC has alleged is that the three underwriters came to an agreement with the ANZ Bank to progressively sell down each of their shares in ANZ. So to slowly sell down 25.5 million shares. Obviously, the reason for that would have been to prevent a big dump of shares onto the market, which would have depressed the ANZ share price significantly. The context of the case is also that JP Morgan received some advice that it may have engaged in cartel behaviour and sought immunity from the ACCC. So it was effectively the party that informed on the other parties to the transaction. Now, the background to this particular case is also important. This is one of the further attempts by the defendants to have the indictment quashed as being so deficient that it can't be sustained. And there was an early decision on the 7th of July by Wigney where he went through a range of complaints about the indictments filed by the Commonwealth Director of Public Prosecutions and ordered that they file a new indictment that would remedy all these defects and deficiencies. And that case could be, the reference is there. Now, the prosecutor eventually did file a new indictment, and I've used the word there in purported compliance with the order. Now, the decision in the case, just to summarise, is that Wigney, the court, held that the arguments by the accused that there were problems with the indictment were valid. Having said that, even though there were serious deficiencies and defective aspects of the indictment, Wigney decided that on balance that he would not actually quash the indictment and discharge the accused. Rather, he decided to give the prosecutor another opportunity to prepare a valid indictment and file it in the proceedings. What's notable here is that it's the last chance that the prosecutor will have to prepare an indictment which complies both with the federal court criminal proceeding rules as well as the common law requirements. So this is a last chance. Now, the changes which the DPP made to the indictment after the earlier decision were quite significant. The first major change was to reduce the number of charges by effectively excluding two of the three agreements from the charges. The ACCC alleged that there was three agreements: the Friday understanding, the Monday understanding, and the 5 to 7% understanding. In the new indictment, both the Friday and Monday understandings were removed as charges, leaving only the 5 to 7% understanding. So that's a big chunk of the case that's been removed from the indictment. Now, one consequence of that change was Mr. Roberts, who was from Citigroup, was no longer subject to any charges because he had only been charged in relation to the fried understanding. So as a result of this change, he was no longer accused of any offences and he was discharged. The other significant change related to the charges against ANZ and Muscati. Effectively, they had been accused of being an accessory to the conduct of other parties, namely JP Morgan. Previously, the ACCC had sought to rely on the accessorial provisions of the Competition and Consumer Act to say that both ANZ and Mr Muscati had been knowingly concerned in aiding and abetting the contravention. In the new indictment, they changed that to rely on section 11.23A of the Criminal Code, which is a complicated provision that creates accessorial liability. And effectively, the prosecutor was arguing that ANZ and Muscati intended to encourage and counsel or procure JP Morgan to give effect to the 5 to 7% understanding. The key issue here is that the legislation uses the terms of the type. So it's important to be able to define what is meant by a cartel provision of the type particularised in the indictment. Now, the first thing to realise is what's the court's role in all this, and Wigney made it quite clear that he can't compel the prosecutor to particularise the charges in any particular way. He isn't there to assist them in how to draft the charges. But on the other hand, it's important for the court to provide guidance, not only to assist the defendant so they understand the charges that they're facing, but there's this overarching purpose to facilitate the fair, efficient and timely determination of criminal proceedings, and also the efficient use of judicial and administrative resources. So there's this overarching purpose to facilitate the case coming on in an efficient manner so that the matter can be dealt with quickly, which is a benefit to all parties. And when deciding whether to quash an indictment, what the court has to consider is, on the one hand, the fairness to the accused of having matters drag on, also whether any delays will cause the accused prejudice, these factors. But on the other hand, there's a public interest in having serious criminal charges heard and determined by a trial by jury. Now, in this particular case, Justice Wigney wrestled with these factors quite a lot, but ultimately decided that the public interest won out and that there wouldn't be significant prejudice to the defendants. So looking at the conclusions of the court, there's a range of different conclusions. The first relate to Citigroup and Deutsche Bank charges, and Wigney identified formal defects in each of the charges against these two companies in terms of how the cartel provision was identified and also the particulars of knowledge which were seen to be deficient and inadequate. So those things had to be rectified in any future indictment. He did not find that the particulars of the conduct had any formal defects. Then in relation to the four personal defendants, he also found, Justice Wigney, there were problems with these charges in the indictment. Again, the particulars of the principal offence were not clear, and also the particulars of knowledge which constituted the principal offences were deficient. So those issues will have to be rectified in the future indictment. He again didn't find the particulars of the conduct had any formal defects. By far the biggest concern that the court had was in relation to the charges against Mr Muscati and ANZ. Wigney concluded that the knowledge and intention, the way that was pleaded in the indictment, was deficient and defective and had to be redone. Furthermore, the particulars of what Muscati actually knew about JP Morgan's contravention needed to be spelled out much more clearly. There was also a concern that the change from the accessorial provisions in the Competition and Consumer Act to the provisions in the Criminal Code had meant that there had to be a number of other changes to the indictment, including a definition of the type of conduct which the prosecutor was referring to. The disposition of the case was that the court ordered that the prosecutor had to file within 14 days of the judgment a new indictment which remedied the defects and deficiencies in the earlier indictment and was spelled out in his judgment. Effectively, there was also a guillotine order that if the prosecutor did not file a new amended indictment within the relevant time, or did file one within the relevant time which was not compliant, then that would be the last chance they would get. If that's correct, then the case could be over. If effectively the prosecutor is unable to remedy all the defects, they're not going to get another chance. Now, the criticisms by the court were quite extensive, and he criticised a number of aspects of it. He criticised the problems with the indictment, and he described them quite memorably as a complete schmozzle, and noted that it had been 3 years for the prosecutor to try and get this indictment ready for a trial that's supposed to start next year in 2022. So that was a major concern. The other concern that Wigney identified is the failure of the prosecutor to take heed of not only the comments made and concerns raised by the defendants about the indictment, but also, more significantly, as you can see there, what the court said about the problems with the indictment. So here he's referring to the earlier case in July where Wigney spelled out all the problems with the indictment, and he's saying here that the prosecutor doesn't seem to have taken any note of those suggestions which Wigney made. Probably even more significantly is Wigney's criticisms of the legislation, and this is a very memorable quote. I'll just read the first part of it. Those responsible for drafting the cartel offence provisions in the Competition and Consumer Act, none of whom could ever have possibly set foot in a criminal trial court before, appear to approach the drafting task as if it were akin to producing a cryptic crossword. So that's very clear criticism that the people who put this legislation together didn't understand the way that criminal trial courts operate and the burdens of proof which need to be established beyond reasonable doubt. He goes on to say the offence provisions, when read with the extensive definitions of the terms used in them, are prolix, convoluted and labyrinthine, which seems to be a very prolix, convoluted and labyrinthine way of criticising legislation. But he's saying this legislation on its face is just very difficult to use. Then he goes on to point out that when you look at the legislation, the cartel legislation in the Competition and Consumer Act, and you add on the complexity associated with the criminal code, particularly the provisions about accessorial liability, then it becomes almost impossible. And then at the end he concludes, by the time the maze of provisions is worked through, it is very easy to lose sight of exactly what conduct the offence provisions are intended to bring to account and punish. So this doesn't augur well for future criminal cartel prosecutions, because it is really, really complicated and difficult. Now, one thing that should be noted is that just before the decision was released, the DPP made a decision to withdraw the charges against both ANZ and Mr. Muscati. And I think that's probably the consequence of a realisation by the prosecutor that they couldn't actually frame the indictment in a manner that would cross the line. So they've dropped the charges against both those individuals. And just a bit of commentary on the case, and I guess just looking at it from an external point of view, it just seems to me that the way the case has been run, that it was rushed at the beginning. It just seems to me that when you're running any litigation, particularly complex criminal litigation, you have to have a clear case theory that you've worked out, that you've been able to cross-reference with the evidence and that you can establish. And it just seems to me that there was a rush to get the case into court. The case theory hadn't been thought out. The evidence hadn't been tallied up to the allegations. And so now the inadequate preparation is coming back and creating a lot of problems for the prosecutor and the ACCC. The second more significant problem is the lack of criminality. I remember running a couple of cases with the DPP, and they said to me, the key issue here is criminality, that the individual we're going to charge or the corporation has a knowledge and understanding that what they've done is a crime. And that's the sort of the main factor that'll end up in a conviction. And here there just doesn't seem to be a high level of criminality. It doesn't appear, to me at least, that the bankers understood what they were doing was a crime. It was pretty well standard industry practice for underwriters to talk about how to dispose shares. And there's a strong suggestion, I think, that the corporate regulator, the Australian Securities Investment Commission, knew about this behaviour and almost countenanced it. Obviously, ASIC's main role is to make sure that markets operate efficiently and they're not subject to major shocks. And so this conduct by the bankers seems to be consistent with that overarching goal. So the lack of criminality is a big problem, which could ultimately mean that even if the prosecutor gets over the threshold of getting a valid indictment through, the jury may acquit. So that's all I have about the case. If you have any questions about this presentation, please give me a call or send me an email. Bye-bye.